A copy. Okay, now we're recording. I apologize. So who is impacted? Foreign nationals who are outside of the United States. So remember that you have to meet all three of these requirements. Outside of the United States, do not have a current non-immigrant visa, and do not have a valid official travel document like a transportation letter, a boarding foil, or an advance parole document. So that's who is impacted, and only foreign nationals who hold certain non-immigrant visa classifications. So this does not apply to anyone and everyone who is in the United States, who is outside of the United States. Rather, it only applies to people who are on H-1B or applying, seeking to enter the United States on H-1B or H-2B. Our office doesn't deal a lot with H-2B visas, but they're for seasonal workers. So if a lot of times it's used for grass care companies or lawn care companies, they will bring in individuals to help just seasonally. It can also be used at ski resorts, places like that, but that's what the H-2B visa is. And any foreign national accompanying or following to join, that means dependents of the H-1B. Likewise, people who are seeking to enter the United States on a J-1 visa. The J-1 classification is used for multiple purposes. It's an intercultural exchange classification. That's its intended purpose. So it's used for all different things, including research scholars and including the individuals or the classifications that are listed here. So only J-1s who are listed here are affected by this particular proclamation. So that is interns, trainees, teachers, camp counselors, au pairs, or summer work travel programs. Believe it or not, that does not encompass the whole J-1 program. I know it seems pretty extensive, but it does not include everyone. Like I said, researchers, long-term and short-term researchers are not included in that. And then of course it includes the dependents as well. And then in addition, it includes the L visas, so the L1A and L1B, and any foreign national accompanying, which is the L2, the dependents, the spouses or children of the L1s. So again, you are affected by the proclamation if you are outside of the United States and you're seeking to enter in one of these classifications and you don't have a valid visa or another valid travel document. Who is not impacted? As I said, we've had a lot of questions, understandably, from clients about, I'm in the United States, my H-1B extension is underway, or my L extension is underway, or I want to file a transfer, am I affected? The answer is, if you are in the United States right now as a foreign national, then you are not included in the proclamation. So if you are in H-1B status, H-2B, J, or L status in the United States, and you don't plan to travel outside the United States, which we would recommend, obviously, at this time, then you're not affected. This includes CAP cases. Likewise, other non-immigrant visa classifications are not affected. They're not impacted at all, at least right now. So for example, if you are on an E or an R, there's for almost every letter of the alphabet, there's a different visa classification. So the proclamation only affects the H, H-2B, J, and L. And as I said, if you're inside the United States, you are not impacted. So that means that this does not include H-1B CAP cases. So if you or your employee has filed an H-1B CAP case requesting change of status in the United States, meaning you're requesting to change from some status like F1 or H4 to H-1B status, then you're not affected. It also includes petitions for H-1B extensions, amendments, transfers for H-1Bs, H-4, H-2B, J, and L petitions if you're in the United States. Going back to the CAP for just a minute, it does affect people who have filed for a CAP petition and requested consular processing. So if a person requests consular processing, that means that they are going to apply for the H-1B visa at the US consulate overseas and use that visa to enter the United States. That is prohibited. So the petition itself would be approved, but the visa at the US consulate would not likely be approved unless it meets one of the exceptions that we'll talk about in a minute. Likewise, people who are outside of the United States, according to a strict reading, I would say, of this proclamation, people who are outside of the United States right now with the H-1B, with a valid H-1B, H-2B, J, or L visa should not be subject to the proclamation. I say should not be because that's how, if you read the proclamation, which is worded in a way probably that I would not have worded it. I would have probably done it a little bit differently, but that's okay, I'm not in charge. But if you hold a valid visa, according to our reading of the proclamation as it currently stands, you would be able to enter the United States. I say that with a lot of hesitancy because I can't control the officers at the port of entry. So if you do need to enter the United States and you already hold a valid visa, one of these visas, if you're one of our clients, please, please, please coordinate with us before you try to enter the United States. We want to try to help you and make that process as smooth as possible. I hope that you won't have any problems, but as I said, we can't control what the officer does at the port of entry. Likewise, individuals filing perms and I-140 petitions, those are part of the employment-based process. Those are not part of the proclamation. And we didn't list it here, but family-based processes that are happening within the United States also are not affected. Who else is not impacted by the proclamation? So it seems like, over this past week, we've received lots of emails from clients and prospective clients saying, oh my goodness, it sounds like they're shutting down all of legal immigration. And it's a huge thing. And I'm not making light of it at all. But it is not quite as extensive as some might make it out to be. So it does not include lawful permanent residents. That means green card holders. It does not affect. Spouses or children of a US citizen, it does not affect. There are also certain exceptions. Let's say that you are a person who is seeking to enter the United States and one of the affected visa classifications, you don't have a valid visa yet, so you would be subject to the proclamation. There are certain exceptions to the proclamation. That is foreign nationals seeking to enter the United States to provide temporary labor or services essential to the US food supply chain, or foreign nationals whose entry would be in the national interest of the United States. For both of these exceptions, there's no set definition. There's no information or guidance from any government entity right now that says, this is what we're looking at, these are the things we're going to consider. They have not told us this is how you apply to seek an exception. So the only information that I have right now, we don't have any information at all. If I had a client who was trying to or wanted to apply for a visa, I would imagine that would need to be done and the argument for the exception would need to be made at the consulate. But again, we don't have any information, and I don't know that we'll get that information. I think it'll have to be let's see how it plays out as we go along. But we don't have information right now from the government on how to seek that exception or what the standards will be. In addition, there's a country-specific exemption, and that is for Canada. Our neighbors to the north are visa exempt in general. So this is not specific to the proclamation, but just in general, a Canadian citizen does not need a visa to enter the United States. There are certain exceptions to that. For example, if you're going to enter the US on a K-1 visa, a fiancé visa, you do have to have a visa even as a Canadian citizen. But in general, Canadians are visa exempt. AILA, the American Immigration Lawyers Association, has a liaison committee with different agencies in the federal government. And they have confirmed, the AILA CBP liaison has confirmed that with CBP, that Canadian citizens entering the United States are not subject to the proclamation. They're exempt. And CBP says that they've given guidance to that effect to all the ports of entry, the CBP, the officers at the ports of entry. So again, if you're one of our clients and you're Canadian and planning to enter the United States on one of these visas, an H or L or J, please let us know, because we want to make sure that we do whatever we can to make that go smoothly. But keep in mind that Canadians are visa exempt and not subject to this proclamation. We appreciate CBP confirming that and AILA's work on that. So timeframe considerations. This proclamation, so remember, this is the same proclamation that occurred, or that was issued rather, in April 22nd of 2020. So this new announcement that came out in June says that the proclamation is going to expire on December 31st, 2020. So in other words, the original April proclamation has been extended to December 31st of 2020. There's going to be a 30-day initial review. So that means that within 30 days of June 24th, when it becomes effective, they're going to review it. And then they say they're going to provide additional or implement additional reviews every 60 days after that. Again, we don't have information as to what that means or exactly what they're going to be reviewing. I don't anticipate changes that would be favorable to foreign nationals during that time. It's possible that they would make some changes, let's say, to further extend the lost my train of thought, to further extend the proclamation. And they specifically say that that might happen. So it's not guaranteed to end on December 31st, or it may be, maybe something good would happen from the review. We're finding that I personally think it's really, I think the whole thing is not appropriate, but I think it's possible maybe that they would eliminate the dependent requirements. We have several clients who are here in the United States on H-1B, and we're separating families essentially by not letting dependents enter the United States. We have some who are here on H-1B and their spouses are overseas for whatever reason. Right now, there's no exception to that. Those H-4 or J2 or L2 spouses and children are still subject to the proclamation, and so families are separated. I hope that will change in the future, but right now there's no indication of that. So that's our information about the proclamation. For USCIS updates, as you may know, USCIS closed in March for in-person appointments. So that means biometrics, which is a fingerprinting appointment, in-person interviews, and oath ceremonies. USCIS is slowly reopening. They were going to reopen in June. There was and I think that they've started doing that in very slow phases. There was a webinar, and we actually just before this webinar, I published a blog post on USCIS reopening. But there was a webinar on June 18th that USCIS had for stakeholders, and they said that they are going to implement first the oath ceremonies because they say that those are shorter and they think safer to do, and then they're going to work on reinstituting the biometrics appointments and the in-person appointments, and they hope to do that before the end of July. So hopefully that will happen. They apparently are not opening all field offices at the same time, kind of on a blanket basis. Instead, they're doing it on a case-by-case basis. They haven't given us information as to what criteria they use to determine who's reopening when, or how we can find out who's reopening when. So our advice right now is to check the website of the field office that is in question. So if you are scheduled for an interview at the Norfolk field office, for example, first of all, if you're our client, as soon as we have information from Norfolk, we'll certainly share that with you all. We have, again, AILA has a liaison relationship with Norfolk. So if we have information that's not publicly available, or even if it is, we'll share that information with you. But otherwise, go directly to the website if you're not our client, or if you just want to check for yourself, you can go to the website of the local field office and they should post opening information there. When USCIS reopens, just like the rest of life, things will not be the same. They may never be the same. But for now, with USCIS, Application support centers, so that's where fingerprinting is done, where they do fingerprinting and photos. Those will start to reopen in phases beginning on July 13th. No walk-ins. You have to have a scheduled appointment to go to USCIS, and they ask that you don't arrive more than 15 minutes before your appointment for space considerations. They will reschedule, as I said, oath ceremonies first. That will take priority. There are additional health and sanitation precautions in place. You must wear a mask. There's hand sanitizer available. They may do some of the interviews by video. So if you're having an interview, you would be in one room and the officer would be in a different room, still at USCIS, but it would be done by video. Lots more information, lots more detail about that is published on our blog post on our website that I just published. So take a look at that if you have an interview coming up. And of course, we'll let you know if you are a client of ours, we'll let you know what the specific requirements are. In addition, appointment notices will include the information, the details, the requirements for visiting the USCIS facilities. The interview notices will be, or the interviews rather, will be rescheduled automatically. So if you are either waiting for an interview or biometrics appointment or oath ceremony to be rescheduled, let's say that you had it scheduled and then the pandemic hit and it was canceled, those should be rescheduled automatically. Likewise, if you never had one scheduled, but you were waiting for it to be scheduled, those also should be rescheduled automatically. And of course, contact our office if you have any questions. One more thing about the interviews and the effect of the pandemic and the closing on cases. Lots of people have questions about, is USCIS actually working and what's going on with that? So just starting to look at questions now. We don't know exactly how processing times will be impacted. I will say that in general, we are seeing for some types of cases that the processing times are actually faster than they were before the pandemic, which is amazing. I'll take it. It's great. So for example, we are seeing that H-1B petitions are being approved within a few weeks or a month or two, which is amazing. That is not guaranteed. It's not applying to every single case. So don't plan on that, definitely. But keep in mind that that is happening. So we're thrilled. That shows the officers are able to work. They were able to work from home even before the pandemic. That's something they were set up to do. And with the pandemic, they were able to work from home. So that's great. The cases that are being affected by the closing, of course, are the family-based cases or other cases like naturalization, or H-4 cases even, where the individual applicants or beneficiaries needed to go into USCIS offices for fingerprinting or for an interview or for an oath ceremony. Of course, they weren't able to hold those interviews and events during the pandemic, during the stay-at-home orders, so they're having to work through a backlog of cases. We don't know exactly how long that's going to take. They haven't told us, and they probably don't know themselves, which is understandable. This is new to everyone. So we hope that they will be able to work quickly through everything, but we just don't know what that's going to look like. If you have been, if you're waiting to be rescheduled, those should happen automatically. And I will say that it's nice that USCIS said that they were going to reuse fingerprints whenever they could. I'm not sure why they don't do that in the first place, because fingerprints don't change. But they were able to reuse fingerprints. So for example, with H-4 applicants, if the H-4 applicant had been fingerprinted previously, or anyone, it wasn't limited to H-4 is my understanding, they were able to reuse those fingerprints and still adjudicate the application. So that was nice. So I'm going to turn now to questions. We have several questions here in the chat. If you have other questions that you think of, please feel free to enter those. This go into the chat box. This webinar is until 1, so I'm just gonna answer as many questions as we can during that time. As I said earlier, if your question is very detailed and fact specific, and if it's detailed and fact specific, then I'm going to ask that you set a consultation, because I am not able to give legal advice during a webinar like this. We are recording this, and we're going to send a copy of the recording to everyone who signed up for it. So looking at questions, this is an excellent question. Someone asked, this would obviously change with a change in administration. That's a great question, and something that everyone, you know, all of the immigration lawyers that I've talked to, certainly all of my friends, have been thinking about. We hope that this will change with the administration, and I fully expect that it would. The question is the administration going to change? And that is a topic not for this webinar. But if we have a new administration, I absolutely think that this will be rescinded, and that several other of the newer, in the past few years, policies, immigration policies, will be rescinded. So I'm hopeful that if there's a new administration, that when there's a new administration, that this would end and be a non-issue. O1s are not supposed to be subject to this proclamation. They are not subject to the proclamation. They're not part of it. Someone is saying that they were denied boarding to their flight this past week. There may have been another issue relating to the visa, or it could have been an error on somebody's part. Feel free to contact us if you need help, but O1s are not included. Is it possible to apply for a new H-1B non-cap academic visa if you're currently on J1 and inside the United States? New H-1B non-cap academic visa. Okay, so I think this person is asking, if you're currently on J1 inside the United States, can you file for a cap exempt H-1B petition? I think this person is asking cap exempt in the sense that they're going to work for an institution of higher education, like a university. Universities are cap exempt, meaning they don't have to worry about the numerical cap, H-1B cap. So they are cap exempt. Those institutions are cap exempt. And yes, if you're here on a J1 inside the United States, maintaining status, then you should be able to file a change of status from J1 to H-1B. One thing to keep in mind if you're on J1 is look at whether you're subject to the 2-year home residency requirement, that's section 212E. If you are subject to that, then you need to make sure that you obtain a waiver in order to file a change of status to H-1B. And again, contact us if you have further questions, and we're happy to have a consultation on that. It looks like all restrictions do not apply for spouses of US citizens. In the past, you still needed a status to enter the United States. It was not sufficient to just being married, I assume, to a US citizen. Is the implication that I can enter currently if I only have a marriage certificate from the US without any further status? No, that has not changed. So I believe this person is saying that previously just being married to a US citizen was not sufficient evidence or documentation to be able to enter the United States. You still needed some sort of visa or ESTA, or if you're a Canadian, you could enter the United States as a visa exempt individual. That's still true. So I've said that spouses of US citizens are not impacted by this proclamation, either the original one that happened on 4/22 or this expansion of the proclamation, and that's still true. Spouses and children are not impacted, but it doesn't change the overall requirement that you have valid documentation to enter the United States. You won't be admitted to the United States if you just present a marriage certificate to a US citizen. When embassies reopen, will impacted people still be invited for interview and given a chance to show why they think they can be accepted or given a waiver? That's an excellent question as well. We don't know the answer to that. As I was saying, with the exceptions, they've given us zero guidance as to what the exceptions will be, what the criteria are, what considerations they would be, what they're looking at, and they haven't given us information as to how to apply for those exceptions. My hope is, and it may vary from embassy to embassy, it happens a lot that different posts have slightly different processes. It may be that you would be able to go ahead and schedule an interview for an H or whatever visa you're applying for, and then when you apply for the visa, present the documentation to show that you think that you meet the exception, and hope that the proclamation does not apply to you. Hope that they accept that documentation. It may be, again, we don't know. and it may be post-specific. It may be that when you go to schedule the appointment online, they just won't let you schedule the appointment because they see you're going to apply for an H or J or L. If that's the case, then the next step, if I were handling the case, would be to contact the consulate itself directly and say, look, this person, if I were the attorney, I'd say, look, this person is trying to apply. They're going to apply for an exception. What's the process? So that's the information that we have right now, unfortunately. USCIS is expected to furlough a lot of their employees. Notice is already being sent. Do you think excessive delays should be expected in processing times for the near future? So my understanding, and I just checked this just before the webinar on the USCIS website, is that the furloughs have not, no furloughs have been implemented yet with USCIS. A lot of you may have seen that USCIS says that they're running out of funding for various reasons, and they've asked Congress for a quote unquote bailout. This is the unofficial term. So they've asked for a bailout, and they hope that they'll get that, but if they don't, USCIS has reported to news outlets that they may have to furlough a lot of their employees. Bottom line is, yes, if a furlough happens, I do expect some delays in processing. We don't know right now, if that furlough is going to happen, because they may get the funding that they need from Congress or from another source. I'm very encouraged that USCIS has re-implemented premium processing because that's a good source of income for them and because it's beneficial for our clients. But I'm hopeful that premium processing will help significantly. I don't know. I don't see their numbers, so I don't know exactly what their situation is. But my point is, it's not time to freak out yet. It's time to take that into consideration, of course, but it's not time to worry excessively about that because it hasn't happened yet. So certainly something to keep in mind with your planning, but it may not happen at all. But if there are furloughs, yes, I would expect there to be delays, although we don't know who they would furlough and how they would reallocate the workflow. So it may be that certain types of cases are affected and others not. We just don't know at this point. Automatic visa revalidation, would that be affected? That's a good question, and I don't know the answer to that off the top of my head. Automatic visa revalidation is when a person is in the United States and they want to travel to an adjacent territory like Canada or Mexico and re-enter without having their visa extended. You have to meet certain requirements. But if you're there for 30 days or less in the adjacent territory, you can actually re-enter even with an expired visa. And I don't know how right now how that would be affected. Foreign students about to start college in the US that need a student visa will be able to get one abroad. Foreign students enter the US on F1 visas, and F1 visas are not part of the proclamation at this point. I'm an OPT holder inside the US and it will expire in June 2021. Can I still apply for H-1B visa next year, even if the regulation does not change? Yes, absolutely. Great question. So first, this is not a regulation. That's a legal distinction that probably only us immigration lawyers care about, but this is a proclamation, not a regulation. The reason I say that is regulations are promulgated, they're created through the Administrative Procedures Act, and there has to be a period of notice that's given with the proposed regulation, a comment period, and then notice for the publication of the final rule. So you would have a heads up. That's the way that changes like this are supposed to be made, but they're not sometimes. So anyway, yes, if you're in the United States right now and you're planning on filing an H-1B petition, which is different from a visa, but planning on filing for the H-1B lottery next year, registering for the lottery, that's absolutely fine. As the only reason you would be impacted if you were outside of the United States. So I recommend not traveling outside the United States. But if you're inside the United States and applying for a change of status with the H-1B, whether it's subject to the H-1B cap or not, you're not affected. Processing times can vary case by case. Briefly, elaborate on the different processing times for post-pandemic I-140 approvals, recapture of time on H-1B. This last question, I'm not sure if I understand entirely. If the person who asked it is still here, if you want to clarify, that's fine. I'm not able to speak on the processing times of all the different classifications because there's so many of them. That information is available on the USCIS website. I will say in general, we're seeing approvals very quickly for, in general, not for every case that we file, but in general, we're seeing fast approvals for H's, I-140s. We're not seeing that as much for family-based cases. And of course, I don't file every single type of case that there is. So I don't practice asylum or U visas or, any number of other things. So I can't speak to that. But we are seeing fast approvals for I-140s and H's. Again, that's not a blanket situation. It's just luck as far as we can tell, but I'll take what we can get. I'm in the US and have a valid I-94 and have an H-1B visa stamping appointment in August. The consulate hasn't canceled my appointment yet. Your thoughts? I think that it will probably be canceled. If it's not canceled and you go for the H-1B stamping, then they probably will not approve the visa. So I'm not sure exactly who's asking this question, but if you are one of our clients, please email us and we're happy to help walk you through that. If you're not one of our current clients, feel free to set a time for a consultation and we're happy to help you walk through that. But for anyone, and I didn't say this earlier, I don't think, but for anyone, I would say if you are currently in the United States in H-1B or J or L status, I think it's risky to leave the United States, even if you have a valid visa. So I said earlier that if you have a valid visa as of the date that this proclamation or this extension became effective, which is June 24th, that you should not be affected by the proclamation. But I can't guarantee what's going to happen at the port of entry. So again, if you're one of our clients, please contact us and we'll help advise you on the risks, pros and cons of trying to enter on a visa that was valid at the time of entry. But in general, I plan not to travel. So if you have I lost that question. If you have even if you have a valid I-94 now, and remember, a valid I-94 is different from a valid visa. The visa is the document that you present to the officer at the port of entry when you apply for admission. The I-94 is the document that you get either when you enter the United States or that the CBP officer enters in online, or that you get when you have a petition approved in the United States. It's at the bottom of your H-1B or L approval notice. So that is different. If you have a valid I-94, that does not mean that you're not subject to this proclamation. You would be subject if you don't have a valid visa and if you travel and try to re-enter. So for the person asking about visa stamping in August, I would talk to an attorney before you leave the United States, because if you leave, you might not be able to come back. J2 to H-1B is subject to the consular approval. Is it possible to have an exception and one start a job from October 1st, or do we have to wait until the expiration of the proclamation and stamp? I believe this person is saying that they have filed to change status they have filed an H-1B petition. Sounds like maybe a CAP petition, but I'm not sure. But they have filed an H-1B petition or are thinking of filing an H-1B petition. They're currently in the United States on J2, and on the H-1B petition, they asked for consular processing instead of a change of status. So when we file an H-1B petition or an L, or any number of other petitions, there are certain boxes that we check to request consular processing, meaning the beneficiary wants to go apply for a visa overseas instead of having their status automatically changed. Or we can mark a box that says we request change of status, meaning, hey, USCIS, when you approve this petition for, let's say, an H-1B, we'd like you to please automatically change this person's status from J2 or H4 or whatever they're on to H-1B. So if you filed and requested consular approval, and the petition is approved already, consular approval meaning consular processing, then you can file what's called, or your employer can file what's called an amended H-1B petition to request a change of status instead of consular processing. And you would, of course, have to have that approved before you start working in H-1B status, but you should be able to do that. Can we apply for a waiver, change of J visa to H1? I was told applying for a waiver now would be denied and affect future entries into the US. So To the person who posted this last question, again, I'm not entirely clear on the question. I'm not sure if you want to try to clarify. There are all different types of waivers. I assume you're talking about a waiver for this proclamation. But you also mentioned J visa, and there are waivers for that for the 2-year home residency requirement. So I'm not sure which one you're talking about. If you want to clarify your question, waiver for the residency for 2-year home residency requirement be denied and affecting future entries. I haven't heard anything about that. I don't handle a whole lot of J1 waivers for 2-year home residency requirements like that, but I have not heard that at all. That's something I'm happy to discuss with you in further detail, if that would be helpful. Can Canadians apply for the H-4 at the port of entry? Is it considered essential since US border is closed for most people? Canadian citizens are visa exempt, so they are not subject to this proclamation. And as I said earlier, this person may not have been on at the time, but as I said earlier, the AILA Liaison Committee with CPP has confirmed that Canadian citizens are not subject to this proclamation because they're visa exempt. So yes, if a person is a Canadian citizen, they should be able to apply for the H-4 at the port of entry, even though the question of whether they're essential is, I don't think, relevant. So we're out of questions from the chat right now. It is 12:42. I'm going to see if I have any questions from the registration that I haven't addressed. In the meantime, if you have questions, additional questions, put them in the chat. Otherwise, we will wrap this up in just a minute. Green card holders, one of the questions from the registration was, have green card holders any kind of restrictions to travel outside the United States? No. Spouses of green card holders, yes. So if a spouse of a green card holder has applied for an immigrant visa, they are subject to the proclamation as a 422, and that's been extended until December 31st. But no, otherwise, no, green card holders themselves are not subject to the proclamation. We also had a question of if the executive order affects an existing H-1B worker who's in the US but wants to switch jobs. No, H-1B transfers are not affected unless you have a status issue. Every now and then, an H-1B beneficiary will have a status issue, meaning they weren't paid or they exceeded their 60-day grace period. And if that happens, they may file an H-1B transfer and have it approved, but without the I-94 card. And before this happened, they would just leave the United States, have the visa stamped, and come back in. I say just, like, international travel is no big thing, but that's what they would do. Go back and have their visa stamped and then re-enter. At this point, we don't have that option for H-1B holders and the L and J. So if you have a status issue, I would be very careful about that. But otherwise, yes, you can file an H-1B transfer. H-1B extensions and I-140s already approved. That is not an issue. I have another question in the chat box about the passage of a particular bill. And I apologize, I'm not familiar with that particular bill. This is a private question. But in general, regarding bills, I will say this. I've been practicing for 15 years. And right now, I don't know, there are no bills. There's several bills that we're kind of tracking, but none that I have high hopes of passing. I will say this, in the past 15 years of practice, I practiced under George W. Bush, who was, had a number of pro-immigration initiatives. In 2013, there was something. So I've seen a lot of promising initiatives, legislative initiatives, and really nothing has passed. So I don't mean to be a Debbie Downer or pessimistic, but at this point, I don't think anything's going to pass, especially in this administration and in this economic and political environment. I could be totally wrong on that, and I would love to be, but at this point, I don't see anything passing anytime soon. The impact on current H-1B holders in the US who have received an RFE, it depends on so an RFE is a request for evidence, and it depends on the nature of the RFE. as I said, if it's an RFE that impacts your status or is about your status, and there's a possibility that the petition would be approved but without the I-94, that's a concern. If it's an RFE about something else, like your degree or specialty occupation, I'm less concerned about that in terms of this proclamation. I think I mentioned this before, but I said one of the questions is, I'm in the US with a valid H-1B. My spouse is currently overseas and doesn't have a visa. Does the suspension apply? Yes, unfortunately, it does apply. I actually think that there's going to be a big push, I hope, a big push for changing that, because I don't see the rationale behind that. J2 and L2 spouses can work in the United States, but H4 spouses only can work in certain circumstances. So if the rationale for this particular, the expansion of the proclamation is the economy, and that the administration thinks that immigrants would, or foreign nationals, non-immigrants would potentially take US jobs, that's not really relevant, I don't think, to spouses, but I hope that that will change. But yes, right now, H4 spouses are included. But if you're filing from within the United States, you are not affected. Are there any alternatives if we don't have a visa stamp and we have to leave the country for any family emergency? If you are a client of ours, let us know if you have that situation come up, and we'll advise you depending on the situation at the time. But right now, no, there's not. The only exceptions are the ones that I mentioned previously. 2020 H-1B lottery is not affected. Yes, it's okay to file change of status, and premium processing is still in place. Just checking the time here. The perm process, as I said earlier, is not affected by this. It's not directly related to this topic, but I'm going to answer it anyway. The processing time for the N400 applications, well, I guess I did touch on that earlier. I said that oath ceremonies are going to be the first to be rescheduled, but that doesn't include, of course, the N400 interviews, where you go to take the test and the English language exam and things like that. So we don't know right now how that's going to be affected. I don't know how long it's going to take USCIS to work through the backlog of cases that they had to put on hold because of the stay-at-home orders. And we'll certainly post that information. I know people are very interested in processing times, and we'll certainly post general information about processing times as we see what develops over the course. And you can also check the USCIS website, but sometimes it's more helpful to have practical on-the-ground information. The entry ban is not for J1 research scholars. That's correct. Or postdoc, that's the same thing. Short-term and long-term researchers who are here on J1 are not affected. This is a good question. Does this order apply to one who's working on an H-1B extension receipt notice? I-94 expired previously, and a decision on the H-1B extension is pending. So this is related, or this situation is, if you're in valid H-1B status and you apply for an H-1B extension, you're able to work for up to 240 days in the United States, even if past the expiration of the I-94. So this person is saying, does this order apply to me? The general answer is no, because you're in the United States. So if your petition is approved with the I-94 card, you're good. You stay in the United States and you're not affected by it. If for some reason the H-1B is approved without the I-94 card because you have a status issue, or USCIS thinks you have a status issue, then you have a problem, because you can't just pop out of the United States, have the visa stamped, and then come back in. Again, if you have other questions, put them in the chat box. I'm still reviewing questions that we got from the registration. Any foreseeable impact on green card processing for applicants living in the US? No. One thing that I didn't mention earlier when I was talking about the overall proclamation, the expansion of the proclamation, is, and this is on our blog post about the proclamation, is that the administration has directed the secretaries of Department of Labor, Department of State, and Department of Homeland Security to look at the existing immigration-related programs and make recommendations on changes that might be necessary. This is very similar to the statement that was made in the 422 proclamation, where the administration directed agencies to look at the non-immigrant visa programs. So I'm concerned that they might try to make regulatory changes. Somebody asked previously, is this going to carry over if there's a new administration in January? And my answer is, I really don't think that that'll be the case. If there's a new administration, I think most of this, if not all, will be overturned. But if there is, so let's say that these leaders of these various agencies make recommendations for regulations. As I said earlier, the regulatory changes have to go through the Administrative Procedures Act. That's literally written into the statutes. So it cannot be changed except by Congress. The procedure can't be changed except by Congress, which would take an act of Congress, to get it done. Anyway, they have to go through the Administrative Procedures Act, meaning it will take a while. Our hope is that there would not be enough time left in this administration to make significant or any regulatory changes. That's not guaranteed, but we hope that, and it's not guaranteed we'll have a different administration, but we hope that there's really not going to be time for regulatory changes. But just keep in mind that that is on the radar of the folks that are in charge right now. I'm going to see if we have any other questions that were submitted that we didn't cover that I can answer. Would I-485 change, it's called change of status. Somebody just put in the chat box student visas. Student visas are not affected. Student visas are F1s and they're not affected at this point. I-485, somebody asked a registration question, are I-485's adjustment of status applications affected? No, those are done in the United States and those are not affected. Even if, oh, thank you. I'm so glad. Somebody just messaged that they feel relieved. I'm very glad for that. That's why we do this. I suffer from anxiety myself, not immigration related on behalf of my clients, but I'm an anxious person and I cannot imagine being, I mean, I can somewhat, but I can't imagine what it would like to be like to be in you all's shoes. I know that you must be super, super anxious, and our goal is to provide as much clear information as we can and to alleviate anxiety to the extent that we can. We're not going to sugarcoat it. These are really hard times for lots of reasons. But that's our goal, is to educate people and to make you feel at least a little bit better. So if you feel that way, I'm glad that we've had that impact. All right, it's 12:54. I'm gonna choose one more question and then wrap this up. Spouses of American citizen green card applications, not affected. Oh, we have one more chat question that I'll address. No change. So this question is, H-1B petition filed June 22nd and waiting for their step on OPT. This person also, so the situation is they applied for a CAP, H-1B CAP petition. They also submitted STEM OPT and they're waiting for that. And is there any effect on the change of status? No, fortunately not. And the reason, I'll wrap up with this. The reason for that is that the changes, any further changes to affect people who are in the United States would have to be regulatory changes, as I said, and would have to go through the Administrative Procedures Act. There's a section of the Immigration and Nationality Statute, section 212F, that allows the President of the United States to limit or prohibit the entry of certain foreign nationals where it would be deemed to be in the national interest. It's a pretty broad clause, but it only allows the president to make these exceptions for people who are trying to enter the United States. That's why the proclamation that we've seen so far, the 422 one and this expansion on June 22nd, only affects people outside the United States, because that's the limit of his power, or of the administration's power right now. So that's good. It's not good, obviously, for the people who are affected. And like I said, don't want to make light of this at all. But there is a limit to what can be done. So to wrap up, I want to thank everyone for coming, especially on a summer Friday. I know everyone's ready to get out of the office. I hope that you will read our blog posts. We post there regularly. That's on our website, sumnerimmigration.com. Join our email newsletter. We send email newsletters once a month, usually the first week of the month. It'll be a little bit delayed for July because of the July 4th holiday. But we send those once a month. We don't share information with anyone. You can always unsubscribe when you become a citizen, though we hope you'll stay on to share with your friends. And then RSVP to future webinars. We have these webinars either as something interesting, i.e. not great, sounds comes out, or once a month we host coffee talks with the attorney just for people to ask questions for us. This one will be in lieu of our July one. We'll not do it in July since people will be on vacation. Hope you all will be on vacation or at least taking a break, but we will pick that up again in August. And of course, if something exciting happens between now and then, we'll definitely have another webinar. Thank you all so much for joining. I hope you have a great rest of the afternoon and that you connect with us soon. Take care.
Thank you, Emily.